Okay. Let's start the first question of the day. Rohan is running a grocery store in Delhi. Okay. Grocery store ಇದೆ ಎಲ್ಲಿದೆ ಡೆಲ್ಲಿಯಲ್ಲಿ ಓಕೆನಾ so he sells his grocery business including goodwill ಅಂದ್ರೆ ರೋಹನ್ ಅಂತಂದು goodwill also he is selling now. Goodwill also he is selling, remember one thing. Okay, so ಈಗ ಡೌಟ್ಸ್ ಇದ್ರೆ ಕೇಳಿ, ಡೆಫಿನೆಟ್ಲಿ ಐ ಲವ್ ಟು ಆನ್ಸರ್ ಯುವರ್ ಡೌಟ್ಸ್ ಇನ್ ಬಿಟ್ವೀನ್. ಬಟ್ ಏನಾಗುತ್ತೆ ಈಗ, ವಾಟ್ ಐ ವಾಂಟ್ ಇಸ್ ದಟ್ ಡೌಟ್ ಅಷ್ಟೇ ಅಲ್ಪ. ಈಗ ಸಮ್ ಟೈಮ್ಸ್ ಇದನ್ನ ಆನ್ಸರ್ ಹೆಂಗೆ ಮಾಡ್ಬೇಕ್ರಿ ಸರ್, ಅದು ಕೂಡ ಇಂಪಾರ್ಟೆಂಟ್ ಅಲ್ವಾ. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಈಕ್ವಲ್ ಇಂಪಾರ್ಟೆಂಟ್. ಸೊ ದಟ್ ಆನ್ಸರ್ ಯಾವ ರೀತಿ ಮಾಡಬೇಕು, ಏನು ಮಾಡಬೇಕು, ಪ್ರತಿಯೊಂದರಲ್ಲಿ ಕಾಲ್ ಮಾಡ್ತಾ ಇರ್ತೀನಿ. ಸ್ವಲ್ಪ ಕೇಳಲೆ. ರೈಟ್, he sell his grocery business, right, including goodwill. Goodwill is of how much bacha, 1 lakh ಇದೆ. To Rohit for a sum of 5 lakh. ನೋಡ್ರಿ, ಇವನು ಏನು ಮಾಡಿದಾನೆ, ರೋಹನ್ ಗ್ರಾಸರಿ ಬಿಸ್ನೆಸ್ ಅಲ್ಲಿ ಮಾಡಿದಾನೆ. ಪ್ಲಸ್ ವಾಟ್ ಎವರ್ ದ ನೇಮ್ ಹಿ ಹ್ಯಾಸ್, ಆ ನೇಮ್ ಆಲ್ಸೋ ಹಿ ಆರ್ ಸೆಲ್ಲಿಂಗ್, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಗುಡ್ವಿಲ್. ಗುಡ್ವಿಲ್ ಅಂದ್ರೆ ರೆಪ್ಯುಟೇಷನ್, ವರ್ತ್ 1 lakh rupees reputation goodwill plus grocery. ಟೋಟಲ್ ಎಷ್ಟಾಗುತ್ತೆ, 5 lakh rupees ಗೆ ಮಾಡಿದಾನ ಅವನು. he has sold it. After the sale of the goodwill, Rohit made an agreement with the Rohan. ಒಮ್ಮೆ goodwill ಸೇಲ್ ಆದ್ಮೇಲೆ ರೋಹಿತ್ the buyer made an agreement with the Rohan. As per this agreement, Rohan is not open another grocery store similar kind of business in the whole of India for next 10 years. Iga Rohan is running a business and he has a good reputation. He sold it for 1 lakh and business for 5 lakh. Now after the sale, the buyer Rohit made an agreement with the Rohan not to open any grocery store similar kind of business in whole India for next 10 years. Next 10 years. Right? However, Rohan opens another store in the same city in 2 months later. ಏನಾಗ್ತಾ ಇದೆ, Rohan has opened another store in the same city for after 2 months. What are the rights available with the Rohit regarding restriction imposed on Rohan with reference to Indian Contract Act? ನೋಡಿ, ಸ್ವಲ್ಪ ಓದ್ರಿಪ್ಪ ಅದನ್ನ. ಓಕೆ, ಇಲ್ಲಿ ಮನೆಯಲ್ಲಿ ತಲೆ ತಿಂತಾ ಇದಾವ ಒಂದಕ್ಕೆ ಒಂದು. ಸ್ಟಾರ್ಟ್ ನಾವು. ಈಗ ನೋಡಿ, ಈಗ ರೂಲ್ಸ್ ಏನಿದೆ ಸ್ವಲ್ಪ ಕೇಳಿಪ್ಪ. ಇಲ್ಲಿ ರೂಲ್ಸ್ ವಾಟ್ ಇಟ್ ಸೇಸ್ ದ್ಯಾಟ್, ಸ್ವಲ್ಪ ಕೇಳಲಿ ವಾಟ್ ದ ರೂಲ್ಸ್ ಸೇಡ್ ದ್ಯಾಟ್. ಈಗ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಒಂದಂತೂ ಬಿಸ್ನೆಸ್ ಈಸ್ ಸೆಲ್ಲಿಂಗ್, ರೈಟ್, ಈಸ್ ಸೆಲ್ಲಿಂಗ್ ದ ಬಿಸ್ನೆಸ್ along with the name also, goodwill also has selling. But what it says that Rohit, the buyer, has made the agreement with the purchaser, seller, saying that next 10 years dalli ನೀವು ಯಾವುದೇ ತರದ ಸ್ಟೋರ್ ಓಪನ್ ಮಾಡಂಗಿಲ್ಲ. ರೈಟ್, ಈಗ the seller Rohan opens another store in the same city in 2 months. 2 months later ಆಗ್ಬಿಟ್ಟಿದೆ. What are the rights of the Rohit, the buyer, agreement ಪ್ರಕಾರ regarding this restriction imposed on the Rohan with reference to Indian Contract Acts. ನೋಡಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಇದೆ. ಇಲ್ಲಿ ಏನು ಹೇಳ್ತಾರೆ ನೋಡ್ರಿ, ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಆಗುತ್ತೋ ಇಲ್ಲ, ಸ್ವಲ್ಪ ಕೇಳ್ರಿ ರಿಸ್ಟ್ರಿಕ್ಷನ್ ಆಗುತ್ತಿಲ್ಲ ಅಂತ. ಸೆಕ್ಷನ್ 27 ಆಫ್ ದಿ ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ 1872 ಕೇಳ್ರಿ. ಸೆಕ್ಷನ್ 27 ಆಫ್ ದಿ ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ 1872 provides that any agreement that restrain a person from carrying a lawful trade, profession, business is completely void agreement ಆಗುತ್ತೆ. ನೋಡಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರೆ, ಯಾವುದೇ ತರದ ಅಗ್ರಿಮೆಂಟ್, ಎನಿ ಅಗ್ರಿಮೆಂಟ್ that stops, that make restriction a person from carrying on lawful trade, profession or business is completely void agreement ಆಗುತ್ತೆ. ಏನಾಗುತ್ತೆ ಅದು? void agreement ಆಗುತ್ತೆ. ಹಾಗಿದ್ರೆ ಬಚ್ಚೋ ಇಲ್ಲಿ ನೋಡಿ, however there are certain exception to this rules. ನೋಡಿ ಯಾವುದೇ ತರದ ಅಗ್ರಿಮೆಂಟ್, ಆ ಅಗ್ರಿಮೆಂಟ್ದಲ್ಲಿ ಲಾಫುಲ್ ಟ್ರೇಡ್, ಪ್ರೊಫೆಷನ್, ಬಿಸ್ನೆಸ್ ಮಾಡೋದು ಕಂಪ್ಲೀಟ್ಲಿ ವೈಡ್ ಆಗುತ್ತೆ. ಓಕೆನಾ? ಓಕೆ. however there are certain exception to the rules. One of the statutory exception to include the sale of the goodwill. Sale of the goodwill ಅಲ್ಲಿ ಇದು ಅಪ್ಲೈ ಆಗಂಗಿಲ್ಲ. It is a valid agreement, right? Cannot be a void agreement. The restraint as to the sale of the goodwill would be valid restraint provided. Restraint means stopping, putting a restriction on the sale of the goodwill will be valid agreement provided. What it says? Provided. Condition ಏನಪ್ಪ? Where the restraint is to refrain from carrying on the business. Correct? Restrictions ಇದಾವಲ್ಲ, to refrain from the carrying on the similar business. Yes, first condition. Second, the restraint should within the specified local limit. Okay, local limit ಆಗಿದೆ. The restraint should not carry on the similar business after sale of goodwill to the buyer for a price. ಒಮ್ಮೆ ನೀವು once you have sold the business, and when you have sold goodwill, you cannot reuse the same name and goodwill within local limit, right? Similar type of business. The restriction should be reasonable. Yes, the restriction should be reasonable. All right. But so reasonable of restriction will depends on number of factors considering by court. Any restriction, if you are giving on any business to be carried out, it depends upon number of factors as considered by court. In the given case, Rohan has sold the goodwill, right? Rohan has sold the goodwill, and there is a restraint from not carrying on the same type of the business. Howdilla. So however, restriction imposed by Rohan is unreasonable as he cannot carry the similar business in whole India, because first it was for only local area, and that too next 10 years. So the restriction, whatever the Rohan, the buyer has put, right, the restriction on the restraint of similar kind of trade should be reasonable. It should be reasonable to make a valid agreement. So therefore, Rohit cannot take any legal action against Rohan as the restriction is unreasonable. You know that, right? What are the restrictions we have? Restriction is to stop the carrying on business. Restriction is should be within the specified local limit. Restriction should not carry on the similar business after sale of goodwill, right? And restriction should be reasonable. It should be reasonable. Very important point. If it is not reasonable, what happens is that if it is not reasonable, Rohit cannot have any kind of control or restraint on the Rohan's business. So Rohan as a restriction is unreasonable as per the section 27 of the Indian contract. Yes, okay now? Understood bacho? Understood? Say yes. Here Pushpalata. Understood बच्चा? No doubt? No doubt? ಅರ್ಥ ಆಗಿದೆಯಾ ಹೇಳಮ್ಮ? Okay, let's have a next question now. Let's have a next question, बच्चों. Question number 2. बच्चों, these all are nothing but case studies. These all are nothing but case studies. I'm sure you are going to get for your exams. So guys, if you have any doubt, please ask me. Please ask me. I love to answer all your doubts, बच्चों. ಒಂದೇ ನಿಮಿಷ ಕೊಡಿ, ಇನ್ನು ಸ್ವಲ್ಪ ನಾ ಚೆಕ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಸೊ ದ್ಯಾಟ್ ನಿಮಗೂ ಅದು ಈಸಿ ಆಗಿಬಿಡುತ್ತೆ ಅಂತ. ಹಾಂ ಸರ್. ಹಲೋ, ಚಲೋ ಪುಷ್ಪ ಅರ್ಥ ಆಗಿದೆ? ಪ್ರೀವಿಯಸ್ ಕೇಸ್ ಅಂಡರ್ಸ್ಟೂಡ್ ರೈಟ್? ನೌ ಮಿಸ್ಟರ್ ಎಸ್ ಏಜ್ಡ್ 58 years. ಮಿಸ್ಟರ್ ಎಸ್ ಎಷ್ಟಾಗಿದೆ? 58 years ಆಗಿದೆ. ಪ್ಲೀಸ್ ದಯವಿಟ್ಟು ಟಿಲ್ 1 o'clock ಕಾಯಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಮ್ಮ. ಟುಡೇ ವಿ ಹ್ಯಾವ್ ದಿಸ್ ಸೆಷನ್ ಟಿಲ್ 1 o'clock so that most of all the case studies, case problems we are going to solve and we are going to explain each and everything in very simple and easy method. If you have any doubt, please ask me. Mr. A, yes, age 58 years, was employed in a government department. He is working in where, bacha? Government department. All right. He was going to retire after 2 years. After 2 years, he is going to retire. Mr. D made a proposal to S to apply for voluntary retirement from his post so that Mr. D can appoint in his place. Okay. Listen. S has 58 years of service. He can retire after 60 years. Now, Mr. D has proposed S to apply for voluntary retirement from his post so that in his place what bacha? Mr. D can appoint in his place. Mr. D offered him rupees 10 lakh as a consideration if he get retired. So Mr. S, in order to induce him to retire, right? So he has given some 10 lakh. He offered some 10 lakh rupees. Now the question is that Mr. S refused at the first instance, but when he evaluated the amount offered as a consideration in just double of what the remuneration is to be received during the tenure of next year. Whatever the next 2 years other double it was double, right? Double of his employment. He agreed to receive the consideration and accepted the above agreement to receive the money as a retirement from his office. Whether the above agreement is valid, tell me bacho. Whether the above agreement is valid, explain with the reference of the provision of the Indian Contract Act. So, understood the question? Understood? ಅರ್ಥ ಆಗಿದೆಯಾ? ಇಲ್ಲಿ ಏನಾಗ್ತಾ ಇದೆ, ಒಬ್ಬನಿಗೆ ಇನ್ನೊಬ್ನು ಮಿಸ್ಟರ್ ಎಸ್ ಗೆ ಡಿ ಏನ್ ಮಾಡ್ತಿದ್ದಾನೆ, ರಿಟೈರ್ಡ್ ಆಗಿಬಿಡಪ್ಪ, ನಾನು ನಿಮ್ಗೆ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ತೀನಿ, ಐ ಗಿವ್ ಯು 10 lakh rupees. ಈಗ ಎಸ್ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾನೆ, ನಾ 2 years ಏನು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀನಲ್ಲ ಅದಕ್ಕಿಂತ ಹೆಚ್ಚಿಗೆ ಸ್ಯಾಲರಿ ನನಗೆ ಈಗ 10 ಲಕ್ಷ ಬರ್ತಾ ಇದೆ, ಸೊ ಬೆಟರ್ ಐ ರಿಟೈರ್ಡ್ ಅಂತ ಹೇಳ್ತಿದ್ದಾನೆ. ಮತ್ತೆ ಏನ್ ಟರ್ಮ್ಸ್ ಅಲ್ಲ, ಹಿ ಇಸ್ ಅಗ್ರೀಡ್. So, bachcho, next question is that Section 10 of the Indian Contract Act 1872 provides for legality of the consideration. Consideration legal ide illa. That is also very important. The consideration is legal and their object is also very important. Ille hedri, first of all, bachcho, in this case, consideration was legal or not? It's not. Right? It is public, opposed to public policy. Government job, doing the government job itself is a ದೇವರ ಕೆಲಸ ಆದಂಗೆ, ಪಬ್ಲಿಕ್ ಜಾಬ್ ಇದ್ದಂಗೆ. ಇಲ್ಲಿ ಗೆಟಿಂಗ್ ರಿಟೈರ್ ಫ್ರಮ್ ದ ಗವರ್ಮೆಂಟ್ ಜಾಬ್ ಟು ಗೆಟ್ ಆಫ್ಟರ್ ನೋ ಫಾರ್ ದ ಸೇಕ್ ಆಫ್ ಮನಿ ಇಫ್ ಈಸ್ ಗೆಟಿಂಗ್ ರಿಟೈರ್ ಮೀನ್ಸ್ ಇಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ದ ಪಬ್ಲಿಕ್ ಪಾಲಿಸಿ. ಸೊ ಬಚ್ಚೋ, that is what Section 10 of the Indian Contract Act 1872 provides for legality of the consideration and object to that. Now my dear student, Section 23 of the said Act also state that every agreement for which object or consideration is unlawful, it is completely void. Just remember this. Just remember this, bachcho. All the agreement where the consideration is consideration and object, if it is unlawful, it is completely void. It is completely void. So now, any agreement which is relating to the trafficking of the public office is opposed to the public policy, and hence it is completely void. So public office means government office, right? So public office requires that there should be no money consideration for appointment to an office in which public is interested. Such consideration paid being opposed to public policy and it is unlawful. Correct? Howdala? Any amount received, if your that is objective and consideration is unlawful, it is completely void. And second thing is that, bacho, remember one thing: if anything, any agreement which is against, which is opposed to the public policy, it is void. So in the given case, Mr. S, who was going to retire after 2 years, was proposed by D, correct, to apply for voluntary retirement from his post in order that he can be appointed in his place. So in lieu of D offered Mr. S rupees 10 lakh as a consideration. Mr. S refused initially, but later on he is accepted, right, the money from his office. Here Mr. S promised to promise of sale for Mr. D's employment, correct? Yes or no? Here Mr. S promises of the sale of Mr. D's employment in public services is consideration for MD's promise to pay 10 lakh. So therefore, in the above term provision, Indian Contract Act, the said agreement is not valid. It is not valid, bacho, and it is void as the consideration being opposed to the public policy and it is unlawful. Artha agideya? Understood, my dear student? Tell me fast. Any doubts you have? Bega head Ripa. Done? Pushpalata? Artha kitne manenge? Big head. Understood, right? Okay, next question. What is wagering agreement or wagering agreement? Wagering agreement andrenu. Next, describe the transaction which resemble with the wagering transactions but not void. Remember, you know that, right? What is wagering agreements? Bacho, remember, insurance agreements are there, right? That all are wagering agreements. So now, what is wagering agreement? Describe the transaction which resemble with the wagering agreements but are not void. They are not void. Now, as per the section 30 of the Indian Contract Act 1872, wager is an agreement to give money or money's worth on happening or non-happening of certain event, future certain event. Correct? Yes or no? So an agreement by way of wager is completely void. Completely void it is. An agreement by way of wagering is completely void. Remember, betting, right, gambling, all are what? Void agreement, right? The essence of wager is that each side should stand to win or lose. Each side should stand to win or lose. Correct? That is why it is. What, bacho? If one is losing, another is gaining, means that's why it is void. For example, if A agrees to pay 50,000, B, if it rains, B promised to pay like the amount to A if it does not rain. The agreement by way of wager here. However, if one of the parties has the control over the event, remember, very important point, bacho. If any one of the party, because in any contract there are two parties, right? If any one of the party has control over the event, agreement is not wager, right? So बच्चों, the act gives few cases which resemble the wager but not void. First of all, wagering agreement is completely void, but in certain cases it is not. It is not. Where, sir? It is, look at that. It's completely not void. It's valid. First, cheat fund. Second, commercial transaction of share market, right? And games of skill, athletic competition, a contract of insurance, right? So, bacho, let's discuss now. These are the points where we can say that wagering agreements are valid. Cheat fund. Cheat fund. In case of cheat fund, remember, here the wagering agreement is valid. Certain number of person decided to contribute a fixed sum of specified period and at the end of each month. Cheat now. So the amount so contributed is paid lucky draw of lucky draw, right? So that is also called wagering agreement. It is accepted here. Okay. Okay, my dear student. Second, commercial transaction or share market instructions. Here also wagering agreement, because in the question already, bacho, this question they have asked in the year 20. Remember, very important question there, right? In the transaction, in these transactions, share markets, buying and selling of the shares, right? So that is also nothing but bacho, wagering agreement. Commercial transactions or share market transaction. In this transaction, in which delivery of the goods or share is intended to given to take, do not amount to wager. Got it? Now, game of the skills, like we say that, right? Kaun bane crorepati and all. So, bacho, athletic competition, Olympic and running competition, we have so many things. Crossword puzzles, picture competition, athletic competition, where the prize awarded on the basis of skills, intelligence are the game of the skills, and hence such competition is also valid. Arthagide. According to the Prize Competition Act 1955, prize competition is the game of skills, not the wager, provided in the prize money does not exceed 1,000. Got it? Next and last is a contract. A contract of insurance, right? Wherever we have insurance. हाँ अर्जित, मैं सिखाऊंगा बेटा, थोड़ा रुकना. ये क्लास 7 बजे तक रहेगी, थोड़ा 1 बजे तक रहेगी. इट्स गोइंग टू बी 4-hour लाइव सेशंस. होल्ड ऑन, डेफिनेटली आई टीच, नॉट अ प्रॉब्लम. ठीक है. तो बच्चों, a contract of insurance is a type of contingent contract and it is valid under the law. So bachcho, these are nothing but the question you can expect. What are the types of wagering agreement? Describe the transactions, we got it, which resemble with the wagering transaction but not void. Understood bachcho? Understood my dear student? Now, what is difference between wagering agreement and contract of insurance? See, it is a contingent contract, right? Okay, we'll see that now. So, bachcho, this question has repeated so many times. Remember, a very important. So, wagering agreement or the wagering agreement and contract of insurance, difference is that, bachcho, you have to remember this. 5 marks, you can expect this question, bachcho. Following are the some of the difference between wagering agreement and insurance contract. All right. So, bachcho, now wagering agreement or wagering agreement is nothing but a promise to pay money, right? It is a promise to pay money or money's worth on the happening or non-happening of uncertain event, right? But contract of insurance nothing but bachcho, it is a contract to indemnify the loss. If the loss is taken place, then only they are going to pay. Insurance companies, they'll take the contract only when the event happen, and that happen is nothing but loss. Got it? Understood? Next, there is a no consideration between two parties. There is just a gambling for money. There is no consideration. There is nothing something in return. But the crux of insurance contract is that is the mutual consideration, premium and compensation amount. See, whenever you take insurance, right, you have to pay the premium, but if that event is happen, you will get some money. Got it? Got it, bacho? So these are difference. There is no property in case of wagering agreement, right? There is a betting on the other's life and property, correct? But insured party has insurable interest in the life and property sought to be insured. Understood? So bacho, there is no property in case of wagering agreement. In agreement, we don't have any kind of property, but in insurance agreement, bacho, the insured party, whoever the insured, right, insurable interest in the life and property sought to be insured. Got it? Understood, bacho? Understood? The loser, remember bacho, the loser, whoever the loser is there, right, the loser has to pay the fixed amount on the happening of uncertain event. Whereas, but except life insurance, the contract of insurance indemnify the insured person against the loss only. Correct? Wagering agreement is completely void and unenforceable agreement, whereas insurance agreements are valid and enforceable. Remember these, bacho. No such logical calculations are required in case of logic happened, not happened, but calculation of premium is based on scientific and actual calculation is of risk. What exactly the risk will be? सर जी लॉ का वन डे, हाँ क्या समझा नहीं मैं? अर्जित क्या बोल रहा है तू? बोला मैडम, राइट? दे हैव been regarded as against the public welfare, because see, wagering agreements are against the public policy, against the public welfare, because here you may lose your home, you may lose your property, you may lose your wealth, because gambling is all like wagering agreement, right? सट्टाबाजी बोलते हैं ना. They are beneficial to the society. Insurance agreements are nothing but बच्चों beneficial to the society. Now, can you go for the next, my dear student? Chalo. Explain the type of the contract, right? Yeah, this is the question they have raised in the year 2021. बच्चों, all the important question. आज फर्स्ट डे, हाँ क्या मैराथन का, हाँ बेटा आज फर्स्ट डे है, लेकिन एग्जाम तक रहेंगे डेली के 4 घंटे क्लासेस लॉ पे. आज मेरा प्लान है लॉ कंप्लीटली खत्म कर दूँ. इनकम इंडियन कॉन्ट्रैक्ट एक्ट का प्लान वही है कि पूरा कंप्लीट कर दूँ आज. एंड कल से हम लोग सेल ऑफ द गुड्स एक्ट, एंड मोस्ट प्रॉब्ली 2 दिन में हम लोग पार्टनरशिप तक पहुंच जाएंगे. उसके बाद में कंपनी एक्ट, उतना टाइम नहीं लेगा. ठीक है, चलो. Explain the type of the contract in the following agreement. See, there are 3 agreements here, correct? So we need to know exactly what kind of contract they are, correct? So बच्चों, X promises to sell his scooter to Y for 1 lakh. However, the consent of X has been procured by Y at the gunpoint. It is agreement is on the basis of undue influence, correct? Yes or no? See, X promised to sell his scooter to Y for 1 lakh. However, the consent of the X has been got accepted. The consent has received at the gunpoint. Bacho, listen. See, the contract is voidable here, correct? मैं बोलूंगा, थोड़ा सब्र करना, थोड़ा वेट कर बेटा. अर्चित, right? The contract is voidable as the X aggrieved party, and the contract is voidable at the option his option, but not the option of Y. It means if X accept the contract can be valid contract, correct? Then Y has no option to cancel the contract. So it is a contract where acceptance has got it, the consent has received, which is not free. And on the option of the party whose consent is not free, he can void the contract. Voidable at the option of the X. Got it? Understood, bachcho? Next, A bought a goods from B in 2015, but no payment was made till 2019. My God, 4 months, 4 years is over. So bachcho, the contract is unenforceable. B cannot sue A for the payment of 2019 as it is crossed more than 3 years. When the contract is crossed more than 3 years, it is barred by limitations. Remember, it is barred by limitation act. A good debt become unenforceable after the period of 3 years. It is barred by limitation act. Got it? Understood, bacho? Understood? Here, A bought a good, so they cannot, right? B cannot enforce it. B cannot enforce as it is barred by limitation of the act. Got it, my dear student? Got it? Next, G. G agrees to give a tuitions to H, a pre-engineering student, from the next month. H in consideration promised to pay G 5,000 per month. Bacho, see, where G agrees to give tuition to H is a pre-engineering student, from next month H in consideration promised to pay 5,000. The contract is executory contract because once the tuition is started, then only he's going to pay, because it's yet to be carried out. Understood? Understood, my dear student? समझ में आया? पुष्पलता हेडमा अर्थ आगे दिया? मुंदो गोवा? Tell me fast. No doubt? Understood, my dear student? Please respond, Madi. Respond, Guruji. Understood all the terms? First contract where the consent is received on the gunpoint. That means simple. The contract is voidable at the option of the party whose consent is not free. Correct. Second, bacho, it is a time bar debt. Cannot enforce. Third is that it is executory contract. So executory agreement, we can say that. Next, Sheena was a classical dancer. Okay, bachcho, this is the last year question already. May 22. Remember, a very important. Sheena was a classical dancer. She entered into agreement with Sheetal Vidya Mandir for 60 dance to be performed. Sheena is a dancer. She has got agreement with some dancing school. As per the contract, because Sheena has to give 60 dance. As per the contract, in contract it is she was supposed to perform every weekend. She is supposed to perform every weekend. Correct? Means approximately, if you calculate that, in a month, every weekend means 2 dances. In a week, 2 dances. 4 means 8. And she will be paid 10,000 per performance. Every week she is going to get 20,000. However, after a month she was absent. After 1 month she was absent without informing due to her personal reason. Answer the following question as per the Indian Contract Act. But you understand this now? The contract is for 60 dance. She has done only 8 dance. After that, she is not regular and she is absent here. Now, tell me whether the management of Sheetal Vidya Mandir has the right to terminate the contract because of performance and non-performance. Again, that is also important. If the management of Sheetal Mandir is informed Sheena about its continuance, can the management still cancel the contract after a month on his ground of subsequently? Next, can Sheetal Mandir see all the benefits, all the powers, all the control has diverted to Sheeta Mandil because the offerer, the proposer, because see, Sheena has not performed his act. Can Sheetal Vidya Mandir claim the damages that he has suffered because of his breach of any of the above cases? So guys, there are 3 cases we have. Let's discuss now. Remember, performance is a very important. If performance, any party refuse to perform as per the promise, yes, they will be liable for damages. They have to pay it. As per the provision of Indian Contract Act 1872, when a party to a contract refuse to perform or he is disabled himself from performing his promise entirely, the following two rights accrue to the promisee. Who is the promisee? The agreed party, the party who suffered because of non-performance of other party. Right? So, bachcho, first they can terminate the contract. Correct? Second, to indicate by word or by conduct that he is interested in continuation. In the case of rightfully cancel the contract, he shall also have the right to claim the damage. Remember, they do have a right to claim the damage. On the other hand, if he accepts the contract, he can claim the damage if specified. Either of the two cases, promisee would be able to claim the damage whatever they have suffered. Right? So promise was what, bacha? Promise was for 60 dance and she has performed only 2 dance, I guess. 1 month, 8 dance and she escaped. She is absent due to her personal reason. Now, what they want, let's have a look. What they said is that whether the management of Sheetal Vidya Mandir has a right to terminate the contract. Yes, definitely. We'll discuss that one by one. Let's have a look. Sheenam was a classic dancer. She entered into agreement with the Sheetal Vidya Mandir for 60 dance performance. As per the contract, she was supposed to perform every weekend and she will be paid 10,000 per performance. However, after a month, remember, after a month, she was absent without informing due to her personal. So therefore, yes, management of Sheetal Vidya Mandir has a right to cancel the contract. They can terminate the contract. First point. Second, Sheetal Vidya Mandir has the right to continue the contract with Sheila, but both they have. But once the right is exercised, they cannot subsequently cancel the contract on the grounds. If they are continued, if they have not cancelled the contract, in that case they cannot cancel again. Next, in case Sheetal Vidya Mandir puts an end to the contract, they can even claim the damages. Right? Yes or no? On the other hand, if they accept the performance, they can claim the damages if it is mentioned. Understood, bacho? Understood, my dear student? Any doubts you have? So these are the 4. Yes, they can terminate the contract. Yes, once they can continue. If they continue, subsequently they cannot terminate. And if the contract has come to the end, yes, they can claim the damages whatever they are going to get it. Understood? Understood, बच्चों? समझ में आया? बताओ जी बताओ. एडा पुष्पलता. Understood, बच्चों? No doubt? Now, when a party to a contract has refused to perform, अर्थ ಆಗಿದೆನಾ ಮದು? ಡೌಟ್ ಇಲ್ಲ? When a party to contract has refused to perform or disable himself from performing his promise, it is entirely the promisee may put an end, yes, the contract. Explain. Listen. So, bachcho, according to section, see, this is also previous question paper they have asked in the year May 2020. According to section 39, what it says that, according to section 39, when a party to a contract has refused to perform or disable himself from performing his promise, it's entirely the promisee may put an end to the contract unless he has signed by the word or conduct his acquiescence of continuation. Andre, they can cancel the contract. If they wanted to continue, means they can continue. Once they continue, they cannot cancel. In the case of the following, 2 rights accrue to the agreed party. First, they can cancel the contract. They can terminate the contract. Next, indicate by word, by conduct that he is interested to continue in spite of not performance. The promisee can say that okay, no problem, just continue, we will not cancel the contract. Once they agreed, once they signed, right, of the continuation, they cannot cancel again. Got it? Got it, bacho? So performance of the contract is very important. If any party fails, refuse or disable himself from the performing, the promisee can put an end to the contract. Remember, so there are two agreed party. Agreed party means what, bacho? Agreed party means the person who has, like, the promise, you can say that. Now, in case of promisee decided to continue the contract, he would not entitled to put end. Once the promisee decided, okay, no problem, happened is happened, I want to continue the contract, they cannot put an end to the contract on the ground of subsequently. Later on, he cannot. In either case, the promisee would be able to claim damages. Remember, both the cases, termination or continuation, they can claim the damages, whatever he or she has suffered because of non-breach of the contract. Now, understood, bacho? This is a very important question, bacho. Remember this. You can expect this question for your upcoming exam, for sure. And those who are watching on the YouTube, please like, share and subscribe, bacho. Next, bacho, I want to finish this chapter by today itself. Are you ready, bacho? By, it may be a 1 o'clock, it may be a 2 o'clock, it may be a 3, whatever it is, but I want to finish this chapter. Okay? Okay, my dear student. Next, Mr. X was a disc jockey. Means they are doing the jockey, DJ at a 5-star hotel, right? So, bacho, this is a question they have asked in the year 2021 because performance of the contract is a very important part. Remember, at a 5-star hotel, okay? As per the contract, he is supposed to perform every weekend, twice a week. He will be paid 1,500 per day. However, after a month, X willfully absent. Intentionally, he just don't want to perform the contract himself from the performance. Does the hotel have the right to end the contract? Yes, we can. Just we have discussed, right? Just we have discussed. The hotel send out a mail to X that they are interested to continue the contract and X accept. Can hotel cancel contract after a month of his subsequent grant? No. See, if the hotel send a mail to X that they are interested to continue in spite of not performance, hotel has sent the contract mail to the X, you can continue. And if the X is accept, the hotel cannot cancel the contract after a month on his ground. In which of the cases, termination of the contract or continuance of the contract, can hotel claim the damages? Yes, in both cases, hotel claim the hotel can claim the damages here, right? See, again, same thing we are repeating here. As per the provision of the Indian Contract Act 1872, when the parties to the contract has refused to perform or disable himself from performing the promise entirely, the following two rights, that is promisee, that is hotel has, they can terminate the contract. To indicate by word or by conduct that he is interested, they can continue the contracts. They have two authority here, right? In case rightfully cancel the contract, he shall also have a right to claim the damages on any of the both the cases. In any of the both the cases. On the other hand, if I accept the contract, he can claim the damage also. If specified either of the two cases. Got it? Understood, bacho? So the promise would be able to claim the damages that he has suffered. Now, in the given case, what? In the given case, bacho, Mr. X was a disc jockey at a 5-star hotel, right? He's supposed to perform every weekend, right? Right, bacho? Right, bacho? Listen. He's supposed to perform every weekend, that is twice a week. and would be paid 1,500 per month. However, after a month, Mr. X willfully absent. Intentionally, he is absent. He don't want to perform the contract for the performance. So therefore, hotel can, yes, hotel can has the right to end the contract, right, with X, the DJ, this jockey. Second, the hotel has also right to continue the contract with X, but once the right to exercised, they cannot subsequently cancel the contract on this ground. Once they have sent the mail, if they agreed, that's it. They cannot reconcile. They cannot resign, right, or cancel. Third point, in the case hotel puts an end to the contract, they can claim the damages. On the other hand, macho, if they accept the performance, they can also claim the damages if it is mentioned, right? If it is mentioned. अर्थ ಆಗಿದೆಯಾ? Understood बच्चों? पुष्पलता ಬೇಗ ಹೇಳಮ್ಮ. No doubt? No doubt बच्चों? ठीक है. Now the basic rules is that promiser must perform exactly what he has to be promised to perform. Remember, the basic rule is that what the basic rule said, bacha, the promiser has to perform what he has promised to. Explain, stating the obligation of the parties. What are the responsibilities of the party? Right? हाँ बेटा 7 मार्क्स ही कर लेता हूँ मैं. Sorry. So बच्चों RDP May 20. Basic rule is that promiser must perform exactly what he has promised to perform. बच्चों, very important point. Please try to remember, recall the concept we have discussed in the last class. Performance of the party is a must and should, because whatever they have promised, they have to perform. As per the section 37 of the Indian Contract Act 1872, the parties to contract must either perform or offer to perform their respective promises unless such performance is dispensed with or excused under the provision of the Indian Contract Act or any other law. Means every party in the contract, whatever they have promised, accordingly they have to perform. Right? Accordingly they have to perform. Unless and until it was not to perform, it was mentioned in any of the Indian Contract Act or any other law not to perform, there is no need to perform. Got it? Got it, bacho? So look at that. The parties to the contract must either perform or offer to perform their respective promises unless such promise is dispensed with or excused to perform under the provision of the Indian Contract Act or any other law. A contract, guys, come back to the point. A contract being an agreement, a contract is what, bacha? Being an agreement which is enforceable by law. Contract being an agreement which is enforceable by law, right, and which creates legal obligation which subsists until it is discharged, right? Contract being an agreement enforceable by law, create legal obligation which subsists until discharge. Performance of promise or promises remaining to the perform is principal and most usual mode of discharge. Very important. Remember, very much. Performance of the promise or promises remain to be performed. Is the principal and most usual mode of discharge, the way they have promised. The basic rules, bacho, remember the basic rules is that promiser must perform exactly what he has promised to perform. Whatever they have promised, accordingly they have to perform. The obligation to perform is absolute. Remember, the obligation to perform is absolute. Thus, it may be noted that, remember guys, it may be noted that it is necessary for a party who wants to enforce the promise made to him to perform his promises for himself, or offer to perform promises only after that he can ask the other party to carry on the promises. Got it? See, listen there. It's completely absolute. Thus, what we can say that, bacho, thus it may be noted that it is necessary for the party who wants to enforce the promise made to him, right, to perform his promises for himself or offer to perform his promises. Only after that he can ask other party to carry out his promises. Now, look, promises bind representative. If any representative of the contract is performing, say if there are two parties here, A and B, A's representative is performing the promise on the behalf of A. So any promises bind representatives of the promise in case of death of such promiser before the performance. The promiser died, his or her representative has to perform unless contrary intention to appear in the contract. So for example, A promised to deliver goods to B on certain day on payment of 1 lakh. A dies before the date. A's representative, bacho, remember, A's representative are bound to deliver the goods to B, and B is bound to pay 1 lakh to A's representative. Understood? Understood, bacho? On the other hand, A promised to paint a picture of B by certain day. It is not possible. A dies means its contract cannot be enforced because of what? Impossible to perform, right? Because of impossible to perform. The contract cannot be enforced either by A's representative or by B because it involves personal skill. Understood? Understood? Understood, my dear student? Next question. Next question, my dear student. Look at that. A received certain goods from B, promised to pay 1 lakh. Okay. Later on, A expressed his inability to make a payment. A has received goods from B, promising to pay 1 lakh. Later on, what happened? A expressed his inability to make a payment. C, who is known to A, pays 60,000 to B on behalf of A. Very important point. Guys, I'll explain that here. Just have a look. There are two parties here, A and B. Right? B has given the goods to A here, and A promised to pay him 1 lakh rupees. Later on, A said, I cannot pay. Cannot make the payment. C, maybe a guardian or parent of A. Right? C, who known to A, pays 60,000 to B. Pays 60,000 to B on behalf of A. However, A was not aware of payment. He don't know about it. He don't know exactly A, because he don't know C has paid money B to B, C has paid 60,000 to B. Right? Now, B is intended to sue A for amount of 1 lakh. Now, what happens? B has planning to sue A for 1 lakh. Discuss whether the contention of B is right. Right? Contention of B is right. Next, one more case here. X received goods from Y, promised to pay 60,000. Later on, X expressed inability to make a payment. C who known to X pay 40,000. Same contract, same situation, same. Now, come back to the point, guys. Listen. Here, a contract may be performed by promiser himself. Remember, a contract may be performed by promiser himself, or it may also be performed by third person. Remember, it may be also performed by their representative. Correct? As per the section 41 of the Indian Contract Act 1872, when the promisee accepts performance of the promise from third person, promisee, in case A and B was the promisee and this was the promiser. If he accept, when the promisee accept performance of the promise from third person, he cannot afterward enforce it against the promiser. Once he accept, he cannot enforce against the A, saying that I want full money. That is performance by stranger accepted by the promisee produces the result of discharging the promisers, right? That means once C is perform the contract, that means bachcho, the discharge of what, bacha? This performance of A is discharged here. A's performance is completely discharged, although the later has neither authorized or not ratified act of the third party. In the above case, remember guys, in the above case, A had promised to pay B 1 lakh. A has promised to pay B 1 lakh for goods received by A from B. Later A refuses to pay. Correct? C, who knows A, makes a part payment of 60,000 to B, which B accepts on behalf of A. Acceptance of the payment from C on behalf of A is discharge. Right? It is nothing but discharge. So A's obligation, what is discharge? A's obligation to make a payment. Therefore, B can sue only for remaining 40,000, not for 1 lakh. Right? Right, बच्चों? समझ में आया? अर्थ आगे दिया? Any doubts you have? Bigger head ripa. Understood, बच्चों? Say yes, sir. Performance by third party, performance by stranger is accepted by the promisee. That means, बच्चों, there is a discharge of the promiser. There is a discharge of the contract for the promiser. अर्थ आगे दिया? मुंद होगा ना बच्चों? Can you go for the next? Understood, my dear student? Next, decide with the reason whether the following agreement is valid, void. It's valid or it's void under the provision of the Indian Contract Act 1872. Here, Vijay agrees with the signing to sell his black horse for 3 lakh. Unknown to both the party, the horse was dead at the time of agreement. Impossible to perform the promises, right? So it is void agreement. Void ab initio. Bacho, as per this section 20 of the Indian Contract Act 1872, an agreement under the by mistake of the fact is completely void. Correct? In this case, there is a mistake of the fact as to the existence of subject matter. That is with respect to the selling of the horse. Selling of the horse which was dead at the time of agreement is unknown to both the party. It is completely void agreement. It is completely void agreement. Can you go for the next, bacha? Sarvesh sell goodwill of his shop to Vikas for 10 lakh and promise not to carry on business forever anywhere in India. But it is unreasonable conditions, right? It is unreasonable condition. Agreement is completely void here. Agreement is completely void. So agreement is void as per the section 27 of the Indian Contract Act 1872. An agreement is restrained from trade is completely void. Remember, an agreement which is restrained of trade is void. However, buyer can put such condition on seller of the goodwill not to carry on the same business. provided that the condition must be reasonable regarding, बच्चों, the condition must be reasonable regarding duration, place of the business, right? Lifetime they said it is unreasonable. Since in the given case restraint to carry on the business was forever anywhere in India, so the terms being unreasonable, the agreement is, question is wide here. Got it बच्चों? Understood? अर्थ आगे दिया? Can you go for the next? The contract is void. Which is contract बच्चा? Here it is. X agrees to write a book with publisher. After a few days, X dies. An accident. बच्चों, it is a void agreement because impossible to perform. Impossible to perform. The contract is void as per section 2 subsection G of the Indian Contract Act. Contract which is ceased to be enforceable by law, which cannot be enforceable at all, become void when it is ceased to be enforceable. In the present case, X agrees. Remember, X agrees to write a book with a publisher. After a few days, X dies in accident. The contract is personal skills, right? And death of the writer result in discharge of contract due to supervening impossibility to perform. It's impossible to perform. Here the contract become void due to impossibility to perform of the contract. अर्थ ಆಗಿದೆಯಾ? अर्थ ಆಗಿದೆ ಬಚ್ಚೋ? ನೋಡಿ, ಇದು ಐ ನೋ ದಟ್ ಎಕ್ಸಾಮ್ ಟೈಮ್ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇದೀವಿ, ಬಟ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಅಂಡ್ ಸರಿ ಟೈಮ್ ದಾಗ ನಾವು ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾ ಇದೀವಿ. ಪ್ಲೀಸ್ ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ನೆನಪಿಟ್ಕೊಡ್ರಿ, ರಿಮೆಂಬರ್ ಮಾಡ್ಕೊಡ್ರಿ, ಬಿಕಾಸ್ ದೀಸ್ ಆರ್ ದಿ ಕ್ವಶನ್ಸ್ ಯು ಕ್ಯಾನ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಫಾರ್ ಯುವರ್ ಎಕ್ಸಾಮ್ ಬಚ್ಚೋ. Discharge under the provision of Indian Contract Act. ನೋಡಿ, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ ಅನ್ನ ಡಿಸ್ಕಸ್ ಮಾಡ್ತೀವಿ. ಎಲ್ಲ ಕಂಪ್ಲೀಟ್ ಸಿಲೆಬಸ್ ಒಂದು ಆರ್ಡರ್ ದಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಗ್ತಾ ಇದೆ ಇಲ್ಲಿ. We are covering whole syllabus in a very systematic way. State the grounds upon which contract may be discharged under the provision of Indian Contract Act 1872. On what ground? Discharge means, बच्चों, if they are impossible to perform, they are not able to perform the contract. So बच्चों, listen. Contract may be discharged either by act of the party or by operation of the law, right? So even a party or representative of the party, third person also can perform, correct? So bachcho, discharge means discharge of performance. If the promiser promised, according to promise he has executed the contract, then it's done, right? Which may be actual performance or attempted performance. Actual performance is said to have taken place when each of the party has done what he had agreed to do under the agreement. Got it? Got it, bacha? So, discharge by performance. When the promiser offered to perform his obligation, but promised they refused to accept the performance, it amounts to attempted performance tender. Got it? So this is the first case, bacho. Discharge by performance. So whatever you agreed, by crazy world, good evening beta. ये foundation. Next, discharge by mutual agreement. So contract is discharged by mutual agreement. Section 62 of the Indian Contract Act 1872 provides that if the parties to contract agree to substitute, replace a new contract. Remember, the parties to the contract has agreed to replace a new contract for it, or refund, or remit, or alter. They want to cancel by refunding or altering or remitting the original contract need not to be performed, right? So novation means alteration, rescission means cancellation and doing the new contract alteration, remission are also some ground of nature. It is called discharge by mutual agreement. Understood? Understood, bacho? Next, discharge by impossibility of performance. Yes, impossibility of performance with one, bacho. The impossibility of performance may exist from its initiation. Alternatively, it may be supervening impossibility which may take place owing to unforeseen changes in the law. If there is any law changes, it's impossible to perform, right? That also, in that case also it is discharge. Got it? Got it? The destruction of subject matter and the non-existence or non-occurrence of particular state thing and declaration of war. In all these cases, it's impossible to perform the contract. All right, bacho. Next, discharge by lapse of time. Time bar debt. We discussed, right? The contract should be performed within the specified period as prescribed in the Law of Limitation Act 1963. If it is not performed, the party deprived of remedy at the law. So, bacho, here also it is discharge by lapse of time, you can say. And the next, discharge by operation of the law. It may occur by death of the promisor, by insolvency, is discharged by operation of the law. Discharge by breach of the contract. Right? Next, promise to pay, dispense with the remittance. When the promisee neglects, refuses, in that case also it is discharge. Okay? Next, bacho, very important question. Discharge is done now. An anticipatory breach of the contract is breach of the contract occurring before the time fixed for performance has arrived. So guys, this question is, I think it's a very important question because RTP, MTP, right? In previous question, like previous year also, they have raised so many times. This time also we can expect, bacho. Listen, anticipatory breach. What exactly the anticipatory breach of the contract? Breach means what? You are not performing the promise what you have promised. That is breach of contract. So now again, an anticipatory breach of the contract occur, right? An anticipatory breach of the contract is a breach of the contract occurring before the time fixed. See, the contract is supposed to be performed, and prior to that performance itself they have breached. Discuss the state, also the effect of anticipatory breach. Look, come back to the point, guys. An anticipatory breach of contract is breach of the contract occurring. Breach of the contract occurring before the time fixed for the performance has been arrived. So before performance is to be arrived, before the performance is to be done by the promisor, the contract can be breached, cancelled. When the promisor refuses to altogether to perform his promise and signifies his unwillingness even before the performance has arrived, it is called anticipatory breach. Got it? Got it, bacho? Well before the time. Say, supposed to get the payment and there is some due date for that. Prior to due date, if the contract is cancelled, it is called anticipatory breach. Remember. Okay? So now section 39 of the Indian Contract Act 1872 deals with anticipatory breach of the contract and provides the following. When any party, a party to the contract, has refused to perform or disable himself from performing his promise entirely, the promisee may put an end to the contract. They can claim the damages unless he has signed by the word or conduct to continue the contract. Effect of the anticipatory. Got it? Got it, bacho? So the promisee is excused from performance or from further performance. Further, he get an option. The promisee is no need to do anything. If the promiser has not performed before the due date, it is anticipatory contract, and law says, contract says, promisee is excused from the performance. He no need to do performance anything. Right? Bacho, he can put an end to the contract. To either treat the contract as cancelled and sue the other party for damages from, obviously damage to aayega hi hai, damage to banda padti, right? Reside and sue the other party for damages from the breach of the contract immediately without waiting until the due date of the performance. One thing. Second, he may elect not to cancel but to treat the contract as still it's open. He do have option. No need to cancel. He can keep it as open and wait for the time to performance and then hold the other party responsible for whatever the consequences of non-performance. But in this case, he will keep the contract alive for the benefit of other party. If you want, he can keep the contract for benefit of the other party as well as his own. And guilty party, if he so decide on reconsideration, may still perform his contract. Means the person who is not able to perform the contract, he can perform because he is given the option. Promise, he is given the option to promiser, they can perform. Right, bacho? Understood? Now may still perform his part of the contract and can also take advantages of supervining impossibility which may have affect the discharge of the contract. Understood? Understood, bacho? Understood, my dear student? Tell me fast. To discharge the contract, right? Promise of not performing the contract, we have discussed now. Guys, make it fast. Understood, my dear student? So, point out with the reason whether the following agreements is valid or void. Remember, Kamla promises Ramesh to lend 5 lakh in lieu of consideration that Ramesh gets Kamla's marriage dissolved and he himself marry her. Listen, Kamla promises Ramesh to lend 5 lakh in lieu of consideration that Ramesh get married to Kamla's marriage dissolved and he himself marry her. Now, the agreement is completely void here because as per the section 23 of the Indian Contract Act, an agreement is void if the object and consideration against the public policy. Right? I'm going to go back here. Sohan agrees with Mohan to sell a black horse. Unknowing to both, yeah, we have done this, bacho. This is also done. Ram sell a goodwill, this is also done. Just now I finished, right? In agreement between Prakash and Girish, there is a condition that they will not institute. Okay, we have not done this now. Just now. There is an agreement between Prakash and Girish. There is a condition. There is a condition that they will not institute legal proceeding against each other with the condition, with the consent. Bacho, remember, bacho, whatever the agreement, purely it is void because if any agreement, right, which restrain from legal proceeding is completely void. It's completely void. Right? Right? As per the section of the 28 of the Indian Contract Act. Next, Ram Murthy, who is a citizen of India, enter into agreement with alien friend. Alien friend. Bacho, again, agreement is valid. Agreement with alien friend is valid, but agreement with the alien enemy is void. Got it? Got it, bacho. Now, so guys, here we have one more questions. You can expect these kind of questions for your December written, bacho. Format wise 7 marks, 8 marks you can expect. Please like my video, na, share and subscribe, bacho. To the channel, please subscribe, Matipo. In light of the provision of Indian Contract Act 1872, answer the following. Mr. S and R made a contract wherein S agreed to deliver paper cup manufacturing machine to Mr. R to receive payment on delivery. On delivery date, Mr. R did not pay the agreed price. Decide whether Mr. S is bound to fulfill his promise. Performance is done by one party and waiting for other party. As per the section 51 of the Indian Contract Act, when the contract consists of reciprocal promises, remember, when the contract consists of reciprocal promises to be simultaneously performed, the promiser need not to be perform his promise unless promise is ready and willing to perform his reciprocal promises. Such promises are constitute concurrent condition, and performance of one of the promise is conditional on the performance of other. Right? If one of the promise is not performed, the other two need not to be performed. So, referring to the above provision, in the given case, Mr. S is not bound to deliver the goods to Mr. R since payment is not made by at the time of delivery. Right? So, next, Mr. Y given a loan to Mr. G, rupees 3 lakh. Mr. G defaulted the loan on due date and debt became a time bar debt. Means more than 3 years. Here is after a time bar debt, Mr. G agreed to settle the full amount, Mr. Y. Whether acceptance of time bar debt is a contract which is enforceable by law. Yes, bacho, the very important promise to pay time bar debt, section 225 of the 3, where there is an agreement made in writing and signed by debtors or by his agent to pay wholly or part of the time bar debt, the agreement is completely valid. It is right and binding even though there is a no consideration, right, even though it is a no consideration. In the given case, loan given to Mr. Y to G has become a time bar. Therefore, Mr. G agreed to make a payment of full amount to Mr. Y, referring above provision of the Indian Contract Act 1872. The contract entered between the parties post time bar debt is valid. It's completely valid. So, Mr. G is bound to pay the agreed amount to Mr. Y, provided the above mentioned condition in section fulfilled. Means contract is agreement is valid here. All right, bacho. Next, A and B enter into a contract to supply unique items, alternate of which is not available in the market. Means antique piece they are going to be. A refuses to supply agreed unique item to B. What direction could be given to the court, given by the court on the breach of the contract? Possible. Means because see, here unique item is only one item, right? Where there is a breach of the contract for supply of unique items, mere monetary damages may not be adequate remedy for other party because that kind of product they will not available in the market. In such case, the contract may be given an order for specific performance and direct the party to breach to carry out his promises according to the terms of the contract. Here, in this case, court may direct A to supply the item to B because the refusal to supply agreed unique item cannot be compensated through money. Okay, bacho? Okay. I'll share this PDF with you in Telegram. Please join, bacho. Almost we are going to close this now by 10:30. Can I take 10:30 or tomorrow? A lot of things to. ನಾಳೆ ಮುಗಿಸ್ಬೋದು ಇದನ್ನ. Still we have 1 second. ಅರ್ಥ ಆಯ್ತೇನಮ್ಮ? ಏನು ಕಂಟಿನ್ಯೂ ಮಾಡೋಣ ಅಥವಾ ನಾಳೆ ಮಾಡೋಣ? Tell me. Still we are close to 100 pages. I think tomorrow we can finish. Okay guys, tomorrow morning we have accountancy class. After that I'll take this now. Okay, and economic also I want to take that multiple choice questions. Join our classes ge, and those who are new to the channel, please subscribe madri, share your friends, and join our Telegram channel. That is link is in the description, right? Hello guys, I'll continue tomorrow. Good night. Please watch recorded classes. Definitely I'll share everything, notes and all to you. Telegram channel, please join. So guys.